Welcome to Leis Cotidianas, our everyday law, where we discuss the laws that affect you every day. Coming up next, we'll discuss alternatives to court. Why would you not want to go to court? Are there pros? Are there cons? Is this legal? And how does it work? We'll discuss this and much more coming up next on Leis Cotidianas. Welcome to Leis Cotidianas, our everyday law, where we discuss the laws that affect you every day. Today we will be discussing alternatives to court. When would you want to do something other than go to court? What's out there? What are the options and what are the process? And we have with us today a special guest who's going to help us understand the process and what you might try to do. This is Randy Meyer. Randy Meyer is an attorney here in Atlanta, and he's been practicing for over 30 years. Over the last decade or so, though, Randy has served primarily as a mediator, and he's going to explain to us what a mediator is and what that process is, as well as an arbitrator. He'll go through that as well. I think Randy has probably done over 1,000 mediations in the last decade or so, and he is going to help us understand what are the alternatives to court, why would someone use those, and really what is the process. Thanks for joining us, Randy.
Oh, thank you, Charlotte.
All
Happy
right.
to be here.
Well, let's just start off. I know sometimes folks have maybe heard of what are the different kinds of things that one might do as an alternative to going to court. Can you tell us a little bit about what those processes might be and just explain a little bit how those have evolved?
Primarily the two alternative processes would be mediation and arbitration, and within those two concepts there are all sorts of variations. But essentially the difference between them is that in a mediation, the mediator is not empowered to impose a resolution on the parties. The mediator's function is to essentially break through the positions that the parties have taken, and it often hardened with the difficulties and expense of litigation, and try to find what I call a rough justice, not the kind of thing where somebody feels like they should be carried off the field and go to Disney World, but a rough justice where they are able to resolve their problem and to feel that they were treated fairly and that they could go on with their life. And arbitration is conversely a situation where the arbitrator, or sometimes three arbitrators, are empowered by contract to impose a resolution just like a judge or a jury, and that resolution is binding on the parties. And so, as you might imagine, if you're selected to be an arbitrator, you have a tremendous amount of responsibility and power.
Let's go back a little bit to mediation. I know sometimes that's not a word that folks are familiar with. When you say a mediation, first of all, who would be a mediator, and how would someone become a mediator in a matter? And is it the kind of thing that happens before a lawsuit gets filed, when a lawsuit's already started? Just how would a mediation come into being, and who would a mediator be?
To give you a little bit of a backstory on that, I would say that the process started in earnest about 20 years ago. And the people who were originally involved in it felt that litigation had grown so expensive and so cumbersome and not as effective as it was in, say, Lincoln's time to resolve disputes between people. And so they were very idealistic people. Sometimes they had law degrees, sometimes not. Sometimes they had a history in world peace movements or peace through law. Sociologists, sometimes sociologists with a law degree. Very idealistic people that felt there was a better way. Interestingly, though, as it evolved, it appeared that more and more of the mediations were done by people like me who, perhaps less idealistic, but just trial lawyers, and that's counterintuitive. But I think the reason for that is that mediation, people don't check their passion at the door in a mediation. They don't necessarily agree to like the other side or to see the other side's point of view. And so mediation is a competitive process. And trial lawyers are comfortable with that, and they believe in it, and they're not thrown off off balance by that kind of thing. So I would say that most of the mediations now are probably done by trial lawyers like myself.
Now, how would it come to be that you would get contacted? Would the lawyers make that call? Would the court? And then how would you be selected, for example? How would it come to be that someone would actually be involved in a mediation? Is there a formal process for that, or how does that work?
Well, it's kind of like anything else. You do one and then you do another.
Right.
You may, it's like practicing law or being an actor. Or, you sometimes get cast as somebody who has expertise or experience or success in a certain area. And then if you are successful, then another and another and another. And so it just evolves that way. It's primarily the lawyers, though.
So lawyers would initiate,
Right.
look at the case, and in essence, the two lawyers from the competing sides might say, look, maybe let's try a mediation in this case, see if we can reach some kind of a resolution. And then they might contact someone like you or someone like you.
Right.
Tell me a little bit about, I know a lot of times our clients, when we go into mediation, they maybe have heard the word, they might understand it's sort of a formalized way to settle a matter, but they really don't have any concept of what happens in a mediation, the physical process of it. Where does it happen? How does it happen? What does it look like? Could you give us a little sense of what a mediation physically looks like on any given day, and recognizing there's variations?
Yeah, that's a great question. It typically occurs in a conference room. Sometimes it's a conference room owned or controlled by the mediator. Sometimes it's one party or the other. Some people have issues about neutral territory, some don't.
Okay.
But it usually happens in a conference room, and I know in the cases where I'm an advocate or a litigator that people are often intimidated by it. And what they're afraid of, in part, is that the mediator will be very aggressive with them and will ask them a bunch of questions that they're not prepared for, and or the other side. And I can't say that never happens, but that's not supposed to happen. Conversely, one of the advantages of a mediation is that the person often or should get an opportunity to talk. Mm-hmm. And if you're talking in the courtroom, you're talking in a really structured setting. I mean, people are jumping up, they're objecting, they're saying you can't say that, they're moving to strike your answer, and it's a kind of ridiculous way to communicate. But it's done, because of concern about how information is processed in front of a jury of lay people. But so it's a more comfortable situation in a mediation. And it's remarkable to me how articulate people are, mm-hmm. Because this is their problem. So I always encourage people to talk in the mediation if they want to, and recognizing that they're not public speakers, but they often feel it deeper than anybody in the room. And so they're quite articulate and often quite moving and do a lot to assist their own case.
I didn't mean to interrupt, but what is the process? When would they have an opportunity to speak? Is there like an opening statement? There's obviously not a cross-examination scenario, so how would that develop, where they do get this opportunity to speak, and in what kinds of contexts?
Well, the first thing that happens is the mediator calls or convenes the meeting, and then the mediator tries to tell them something about themselves, hopefully not too much. Hopefully that doesn't dominate. It's not about me.
Right.
But enough to give them confidence that you've had experience, that you know what you're doing, and also the mediator is trying to set a certain tone and start to plant certain ideas, because it's a process where the mediator is trying to persuade people to settle cases and to resolve cases where they've not been able to do it themselves. And so you have to set a certain tone. And then you hear from the lawyer, usually for the plaintiff first, and then that's the point where you encourage the plaintiff to say something, the actual party, not just the lawyer. And that's the point I was talking about, where I'm often just amazed at how articulate and deeply felt these emotions are. And then it's helpful, I think, to get them out there. I mean, there's a defendant and a defense lawyer, and the defense lawyer usually speaks, and hopefully the defendant will speak. And then you, often there's presentations and attempts to persuade the other side, and part of the value of it is the parties are there. It's not just lawyers talking, the parties are actually there. The decision makers are actually there. That's part of the great thing about it. And then you break into what are called caucuses, where, as a practical matter, the more sensitive and confidential information is discussed.
Okay. And it sounds like the benefit for the parties, certainly in this open session, the opening session, the first caucus, is that the plaintiff, for example, will actually hear what it sounds like when the defense lawyer makes an opening statement, sort of a little preview to what the court process might look like. And the same for the defendant. They've been reading the documents and so forth, but it's nice to actually, or it's good to hear, what's this going to actually sound like, and what would it look like in front of 12 folks. So
yes, there's a little bit of test marketing to it, and it's a sensitive moment. And I always try to remind the plaintiff, particularly an individual or unsophisticated individual, that the defense lawyer means no harm, and that the defense lawyer owes the same duty to the defendant that the plaintiff's lawyer owes to the plaintiff. Defense lawyer means no harm, and that it's a free and fair exchange of information, and that's always a good thing.
Well, it also sounds like you've got lawyers who still get to be the advocates, but at least they're moving the process forward and have someone like you to help to facilitate.
Right, and the client is looking for advocacy, which doubles back on what I said about it being a competitive and even aggressive process. The client is looking for advocacy. The client wants to hire an advocate,
right.
a fighter. And so, yes, there is definitely some advocacy, and sometimes the mediator has to try to keep that within bounds, because you want to have a healthy exchange, but you don't want people being wounded.
Right, in order to get it done.
Right.
Well, let's take a break right now, and then in a few moments we'll come back and find out a little bit more about arbitration. Thank you.
Desde el momento en que ellos llegan a nuestras vidas, dan su primer paso, aprenden a andar en bicicleta. Hasta la preparación de su primer día del 5º grado, es un reto para todos los padres criar un hijo saludable. Permítanos guiarle a través de un embarazo seguro y feliz. Aprenda sobre salud, nutrición e información educativa relacionada con el desarrollo de su hijo. Padres e Hijos Atlanta, una publicación del mundo hispánico. Recoja su copia gratis hoy. ¿Cuál es su tesoro más preciado?
Welcome back to Leyes Cotidianas. Today we're discussing alternatives to court. Before the break, we spoke about mediation and how that process works and so forth. And just to kind of wrap up a little bit on that, you talked about there's kind of an opening session, people break off, and then there is at that point an opportunity for the lawyers and the mediator and the client to speak directly with the mediator. And then is there a set tone for what happens after that, or is it really just sort of an organic process that evolves depending on the particular case?
It's a confidential process, and the confidentiality is very sensitive in what's called a caucuses, the private meetings with the parties, which is, by the way, very different from court or arbitration, because these are called ex parte conversations, meaning outside the presence of the other party. But it's an important tool in a mediation, because it's an effort to get past the positions and to get to what the party really needs to have. And if you can find what both parties need, usually that intersects, and you can get what I call that rough justice. If you can get past the positions and the wants and the desires and the fantasies, and you can get to what you need, what do you hear about, and what are you willing to pay to take this all the way through a jury trial? And does that make any sense? Does that make any investment sense? And so it's a touchy thing for a mediator because you have to be aggressive. You can't just be an order taker or a message taker. You have to be aggressive, but you have to be aggressive in kind of a nice way. You know, I mean,
so you're not just shuttling
right.
offers back and forth. Well, they've offered this and then no response. You're not,
right.
in a mediation, you're actually talking to them about, all right, here's their offer, let's talk about this, and let's sort of peel the onion back a little bit.
Peel the onion back is a good way to put it. And you have to honor the lawyer, because the lawyers live with the case 6 months, a year, 2 years, 2.5 years, and knows a lot more than you'll ever know about it. Then you just look at some materials beforehand and you come to this. You have to honor that lawyer, and I'm happy to do that because I do honor lawyers. And you have to honor that party because the party is a little nervous and aggrieved, but also most people don't love litigation.
Right.
I mean, most people rather do something else.
Right.
And a few people do, and you got to be wary of those people, but most people don't love it, and yet they feel aggrieved and they feel like they need to have those grievances answered. So you have to have humility, but you also have to have a certain amount of aggressiveness in order to punch through and to kind of get to that place where their interests intersect. If you get where their interests intersect, which is true of most cases, you know, my got to have and my got to have will intersect usually, and then you can resolve the case and do some good.
Good. All right. Now we focused primarily on mediation. Let's actually now talk about arbitration, the differences between the two, and then really how did the arbitration process evolve, and why would maybe somebody choose arbitration or mediation? Why would somebody do that? I know there's a lot of questions all in one, but let's maybe just sort of start off with what are the differences between arbitration and mediation?
In arbitration, the arbitrator or arbitrators is empowered. You know, you're empowered in mediation with your ability to persuade, but you don't really have to persuade in arbitration because by contract, the parties have agreed to give the final decision to you. So it's more like a trial, actually, or a bench trial, which is a trial before a judge, because you'll put witnesses on, you'll have exhibits. It's a little less formal, but there'll be cross-examination, there'll be opening statements, there'll be closing arguments, so it's something like a trial. An arbitrator is given a lot of power, and it goes back really to the days of Aristotle. It goes back thousands of years when people who had a dispute would come before an elder in the community or the city and ask for a decision. In the Bible, King Solomon. It goes back way before jury trials, and jury trials are kind of a fairly recent invention, going back maybe 200 or 300 years, where they have sort of independent power to make a decision. And jury trials were seen as radical and still are in some places. America is the great proponent of the trial by jury. But arbitration is a much more ancient process.
Now, just to pick up a little bit on that trial by jury, because I think this would interest folks a lot, are you aware, and if you could give us a little bit of background and history on why it is that perhaps the jury trial system was so instrumental in the creation of the United States, and why was that used as opposed to the bench trials and the judge-determined cases? Just to give us a little sense, and then we can come back to arbitrations.
Well, it was called the American Revolution for a reason. These were revolutionaries. I mean, these were people who were brilliant, and it was in a time, the Age of Enlightenment, where our founders saw the chance to make a new world, basically, and to change the relationship between government and the people. Well, what could be more powerful to an individual than to sit on a jury with 6 or 11 other people and make a decision that might involve the most powerful entities or people in that society? It's a huge shift of power away from the government to the people. And America, even though our revolution was conservative, and that's why it survived, unlike the French, it was still a revolution. And it was a radical idea then, And it's an idea that has stood the test of time to today. But having said that, it's expensive.
Right.
It's very expensive to take a case all the way through trial with the motion practice, the discovery practice, the time it takes, the 2 and 3 years to get to a trial. And I think that's what I meant about the idealists said, okay, now there needs to be a better way, but you still have to have the input of the people. You have to have that individual have power and have input to make it a good thing, and that's what happened.
Tell me again now, let's kind of go back to arbitrations a little bit. The arbitration looks like, in essence, a private court setting. Not to oversimplify it, but that's in essence a good component to it.
Yeah.
When parties might agree, it seems like it would come up more in a business scenario where parties might agree to, by contract, look, we'll agree to do it in arbitration rather than going through the expense of a full jury trial and so forth. Particularly from a business, they can make that negotiation. Are arbitrations, let's assume that the decision of the arbitrator, the individual, or if there's 3 of them, the panel of arbitrators, is something that the parties don't like or one party doesn't like. Are they bound by that? Is it something they can appeal, or are there different circumstances?
Great question, because the idea of an arbitration is, okay, this is it. We have resolved our dispute. We've brought in somebody we trust. We brought in the elder. We brought in a lawyer that we trust. This is it. We have resolved this dispute. And if that, and it's cheaper, quicker. Okay, maybe we can do it in 90 days instead of 3 years.
Right.
All that's lost if all of the kind of due process mechanism of the litigation system are imposed on arbitration, such as appeal. It's nearly impossible to appeal an arbitration. You have to have what's called manifest disregard of the law. And I'll tell you, that's a darn high standard. And if you just appeal and go to a superior court because you're unhappy, you can well expect, unless you've got something really good, to get your hand slapped. So the arbitrator actually has more power than a superior court judge because there's, in practical terms, very little power of appeal. So if you're an arbitrator and you want a Coke, you'll get a Coke, like right there, within 30 seconds. It's a great, powerful position and a great responsibility.
Let me ask you, in an arbitration setting, you know, oftentimes we talked about this concept of there's one trial judge, but in an arbitration setting, you mentioned a little bit ago, there might be 3 arbitrators or a panel of arbitrators. Explain a little bit the concept of having 3 arbitrators, sort of 3 judges or 3 in a panel. Why is that a good thing? Why is that something that people gravitate toward?
Great question. It certainly enhances the expense. So that's the negative thing about
Okay.
it, you know, because one idea of an arbitration is, let's get this matter resolved by somebody who's an experienced lawyer in an economically feasible way. Now you got 3, you've tripled the cost, plus the cost of the lawyers. But the reason people do it is they have some concern about putting that much power in one person. So the thought is, if you have 3 and they deliberate, and if somebody's about to go off the rails, the other 2 will pull them back, and you're more likely to get a judgment or a decision that people would recognize. They might not like it, but they would recognize it as rational. So that's the idea.
The idea is it's sort of 3 to counterbalance in the event that somebody is maybe viewing this much, much differently.
Right.
You mentioned a little bit of sort of pros and cons, but let's just talk about for a minute a few pros and cons. Cost is obviously one issue. With all of this, what I would call alternative dispute resolution, mediation or arbitration, what would be some other reasons or pros that someone would want to do that and that it would make sense not to continue all the way through to the court system, if you could? And I think that'll probably be all we're going to be able to have time for today.
Well, I think that I mentioned Lincoln. You know, back in Lincoln's time, they would ride the circuit, and they would come in and they'd interview a couple witnesses, and they'd try 6 or 7 cases in a little town, and they would resolve all the disputes in that town. That was a great thing. But what happened in the 30s, 40s, and 50s, people started saying, well, what if we have like an exchange of information? We require information. And then what that leads to is, well, you didn't give me the information that you're supposed to give me, so
Right.
I'm going to file a motion. So then we get off track and we go try and fight over the information. Or I don't think your case is good enough to go to a jury, so I'll file a motion to knock you out. And so all of that may be leading toward exquisite justice, because it's just due process, but it's not leading to practical justice. And it becomes extremely expensive to take a case all the way through a jury trial. And the truth is, in most cases, you can't afford it. And that's the unfortunate thing about, you know, how this idealism of due process has now become a impractical sort of thing. So this is a way. Another thing is, some people believe that if you have a specialized subject matter, then a specialized arbitrator could be maybe give you a truer decision. I don't know if I entirely agree with that, except maybe in the highest reaches of complexity, because there's something beautiful about 12 people deliberating. But that would be another reason why people would want to arbitrate. You know.
All right. Well, thank you very much for joining us. I appreciate it, and I think we have a much better understanding of generally alternative types of resolution process.
Thank you for having me.
Thank you. Thank you for joining us on Leyes Cotidianas. If you'd like to hear this topic and many more, please join us on the website at leyescotidianas.com.
Leyes Cotidianas les llega a ustedes gracias al generoso apoyo financiero de la Fundación de Justicia Civil del Estado de Georgia. Mundo Hispánico, el vocero de la comunidad hispana desde 1979. La estación transmisora WPBA no tiene licencia para practicar leyes en el estado de Georgia. WPBA y los patrocinadores de este programa no son responsables por las opiniones expresadas ni la información proporcionada por los abogados en este programa. Este programa se ofrece como un servicio público. El objetivo de este programa es de informar y educar y no de proveer consejo legal. Si usted necesita consejo legal, favor de consultar a un abogado.